Namaskar, good evening. You're watching Live Wire and I'm Swati Joshi. Let's begin the broadcast with the developments that took place in the Gyanvapi case and are being seen as a setback to the Hindu side. The Varanasi District Court rejected the plea seeking carbon dating of the structure found in the Wazoo Khana of Gyanvapi complex. The court in its order states that carbon dating of the structure may cause damage to it and that it will violate the Supreme Court's order. Now, the Hindu side is planning to approach the Supreme Court to challenge the District Court's order, as the Hindu side feels that determination of nature of the structure is at the heart of the entire matter.
उस एप्लीकेशन को माननीय न्यायालय ने रिजेक्ट किया है और माननीय न्यायालय ने ये रीजनिंग दिया क्योंकि सुप्रीम कोर्ट ने 17 मई के ऑर्डर से इस एरिया को सील कर रखा था। इसलिए अगर हम कोई भी ऑर्डर पास करेंगे तो वो उस ऑर्डर का उल्लंघन होगा। तो मैं आपके सामने बयान देना चाहता हूं कि इस ऑर्डर के अगेंस्ट हम सुप्रीम कोर्ट जाएंगे। इस ऑर्डर को हम सुप्रीम कोर्ट में चुनौती देंगे। ये ऑर्डर अगेंस्ट द रिकॉर्ड है क्योंकि सुप्रीम कोर्ट ने 20 मई के ऑर्डर से ट्रायल कोर्ट को पावर दी थी कि वो सारी एप्लीकेशन डिसाइड करेंगे। दूसरी बात, ये मांग लेके हम सारे महिलाएं याचिकाकर्ता सुप्रीम कोर्ट गए थे और सुप्रीम कोर्ट ने कहा था कि आप ट्रायल कोर्ट को अप्रोच करिए। तो ट्रायल कोर्ट आज कह रहा है कि हम नहीं कर सकते क्योंकि सुप्रीम कोर्ट ने सील कर रखा है। तो हम इस मांग को लेके अब दोबारा सुप्रीम कोर्ट के सामने जाएंगे।
यह सत्य है कि यह एक पूरा झटका हिंदू समाज को लगा है, लेकिन कोई बात नहीं, हम हाई कोर्ट या सुप्रीम कोर्ट में जाएंगे। दूसरी चीज है कि ये जो कार्बन डेटिंग की मांग है या अन्य वैज्ञानिक प्रणाली की मांग है, हम जो है पुनः हाई कोर्ट या सुप्रीम कोर्ट जाएंगे। लेकिन हिंदू समाज ये अल्पकालिक झटका है, लेकिन इससे हम घबराने वाले नहीं है। नहीं, सिर्फ कार्बन डेटिंग वाले प्रक्रिया को खारिज किया गया है। हम लोग माननीय न्यायालय को समझा नहीं पाए और फिर भी जो भी माननीय न्यायालय का फैसला है हम सिरोधार्य करते हैं। हम संविधान के मानने वाले लोग हैं, कानून का पालन करने वाले लोग हैं। माननीय न्यायालय का जो भी फैसला है हम सिरोधार्य करते हैं।
I was expecting that. In fact, I was expecting him to give the scientific truth also, the judge, that you can't carbon date a rock. You can only carbon date a fossil thing. It's like fish. If you get a rock with a fish in it, fish bones, then you can carbon date. And I know this because I done a lot of work on this issue in the Ram Setu case when people argued that you cannot carbon date Ram Setu because it's all rock. I said it's not a rock.
So as far as the legal aspect is concerned, the big question is what next in the legal fight and what in fact are the options available to the Hindu side now. Let's take a look at the options. The Hindu side can challenge Varanasi Court's order in a higher court in the Supreme Court, like you heard in those reactions. They can seek carbon dating of structures outside the Shivling area. They can seek a nod for other scientific probe to determine the age of the structure and also push for a ASI-like survey which proved key in Ayodhya. Now, to understand both the scientific aspect and the legal aspect, we have experts on the panel. We have Mr. B.R. Mani joining us on the broadcast, DG National Museum, and someone who's directed 20 archaeological excavations throughout India, including the one that took place in Ayodhya. Mr. Mani, thank you very much for joining us. Can you help us understand the scientific process that the Hindu side is seeking to determine the age and the nature of the structure? As per today's order, the court believes if you go for carbon dating or radar ground penetrating, then that might cause damage to the Shivling-like structure.
You want me to answer this question?
Yes, sir. Please go ahead.
Okay. In fact, I was also expecting the same, something of the same sort of judgment from the court, because the rocks cannot be radiocarbon dated. So, and this thing I have already told several times to different channels. Even today morning also I told this. The important aspect is that the nearby area can be excavated, say 2 by 2 meters adjoining the area of the Shivling or Shivling type of structure can be excavated, and from that particular level when it was established there, if some carbon sample comes out, then that can be dated. So that is one aspect for dating of it. So far as ground penetrating radar is concerned, I was the first person to use this in 1993 in Lal Court in Delhi, and then later on it was also used at Ayodhya and other places by me and other colleagues. And this is ground penetrating radar is actually a thing which an instrument through which the rays, the electromagnetic rays are sent to the ground, and when it reflects from after touching some stone or brick object or different soil, then it is recorded in the computer. So that way it gives some alignment of the structure. And here in this case also it's a non-invasive method. It is non-destructive one, so it can be used here also. The third aspect is to determine the age of this particular structure. I believe it is a Shivling because it can't be a Phawara or fountain. Nowhere such type of fountain has ever been found. The fountains which we get from the Mughal times, they are slender, and on the top there is something of a shape of a bud, and then from that the water comes out. Secondly, the water also is put inside the fountain with some pressure, and there is no pond or anything through which the water can come, and it is also not certain that this particular structure is from the lowest side. It has got any hole in it. So how the water can enter in? So that is why I think this is definitely a Shivling. And if it is a Shivling, then we have to know the base of it. And once we come across the base of the Shivling, then from the adjoining area, if we get some carbon sample, that can be dated. And that is not going to touch the Shivling or make any destruction to the Shivling.
So those are very important points that you've just mentioned. And you said you were expecting an order of a similar nature because carbon dating cannot be done on the said structure itself. But if the Hindu side seeks and modifies its petition, seeking a scientific process to be followed in the adjoining area of the Shivling, then that perhaps could help them determine the nature and the age of the structure. Mr. Mani?
Yeah, that's what I think. And that may give a scientific base to understand whether it is a Shivling or something else, or the period when it was established.
All right, Mr. Mani, thank you very much for taking those questions and for putting things into perspective. Thank you for giving us your time. Now, to understand the legal aspect, we have another expert on the panel with us. We have Swapnil Kothari joining us. Swapnil Kothari, good evening to you. Now, as far as the Supreme Court's order is concerned, Swapnil Kothari, the Supreme Court said in order to obviate any dispute on the meaning and content of the order of the trial judge, the operation and ambit of the order dated 16th May 2022 shall stand restricted to the extent that the district magistrate Varanasi shall ensure that the area where the Shivling is stated to have been found as indicated in the order shall be duly protected. Now, the lower court said if there is any damage to the structure, it will not just violate the Supreme Court's order, but also the sentiments, the religious sentiments of the Hindus as well. And that's why the judge said it's not appropriate also to order a ASI-like structure. Now, take us through the legal options available before the Hindu side.
Swati, this order is erroneous. First of all, when the
Supreme Court says that I'm sealing it because I do not want it to be damaged. And then after a few days it says that let the trial court decide. Now once the trial court is going to decide, it sends it back. It refuses to adjudicate upon the matter. So when it sends it to the trial court for adjudication, that means the trial court has got all the powers, whether to reject applications, whether to allow applications, whether to allow partially the applications or not. So that is entirely within the jurisdiction of the trial court, which is what this judge within his powers it was. Now, be that as it may, but he took a different view. He said that if I do this, it will violate the Supreme Court's order. That is unfortunately an erroneous interpretation, because once you're seized of the matter, then you've got to decide upon that. Now, the second point is that if it is going to damage the Shivling structure and it may hurt the sentiments of the people, and that is also the reason why I'm not allowing any scientific inquiry, that is to then undermine the ability of the people who will conduct the scientific inquiry, who are experts in that field. That is to say that, they would not know how to sculpt it out or how to conduct an inquiry of that sort. Now, there is an entirely separate issue, as what my previous panelists mentioned, that a carbon dating, whether it would be fructuous or not, whether it will be fruitful or not, that's an entirely separate issue. That issue has not been mentioned here by the judge in his reasoning. So his reasoning has been dependent upon the fact that Supreme Court's embargo on his adjudication, and secondly, as far as that could be damaging the structure and it could be hurting the sentiment. I believe this is what hurts the sentiments of the people more, especially lawyers like me, who want an adjudication on the matter.
Right.
I'm not interested in either side. I want it either way. Either you say yes or either you say no. Either you allow the application or either you dismiss the application. But the reasons have to be different. They have to be more legal than anything of this nature. And to say that there is a technicality which is stopping him from, adjudicating is a little bit of a fallacy there. Now the Hindu side will have to go to the Supreme Court.
Right.
And will have to seek a clarification and say that, look, your order seems to be, putting up an embargo on this, and so please clarify, and then the Supreme Court
Right, a clarification on that, and perhaps like the expert said, a modification as well. Now, seeking a scientific process to be followed in the adjoining areas, and he also spoke about some
scientific process.
Yes, he spoke about some non-evasive methods as well. So there are scientific processes available. Please finish your point, Swapnil Kothari.
So I think the main point here, that when in a civil suit, I'll try to make it as simple for your viewers. In a civil suit, fact is very important. Establishment of a fact.
Okay.
Then you apply the law once the facts are established. Whether you call it the Places of Worship Act, Monuments Act, Constitution, Article 25, all those come in later. Before that, you need to establish a fact. And to establish a fact, you need to have either a scientific inquiry or a non-scientific inquiry or a survey or whatever you want to call it. So you have to allow a fact finding.
You need to establish the fact first, is what you're saying. Let's see how this plays out in the higher court when the Hindu side approaches the Supreme Court for clarification and modification as far as the case is concerned. Swapnil Kothari, for the moment, thank you very much for joining us on the broadcast. A quick break with that.